those who were released, but then I think in due course, we will have details of those persons and the offences in which they were tried and convicted. But then two pardons have stood out, and that's those for former governor of Plateau State, Joshua Dariye, and ex-governor Johnny Nyame of Taraba State, who were both jailed for stealing 1.16 billion naira and 1.6 billion naira, respectively, tried and convicted by the Economic and Financial Crimes Commission, that's the EFCC. Now, legal luminary Mr. Femi Falana, ACN, had urged the federal government in what looked like an attack on Friday at the first anniversary of the lead spokesman of Afenifere, Yinka Udumaki. At that lecture and representation on Friday in Ikeja, the legal luminary urged a sort of mockery of the federal government under the administration of President Muhammadu Buhari to extend the presidential pardon to people serving terms for petty offences, people across board who were serving various jail terms for petty offences. Now, the Rights Crusader said doing so for convicts without selectivity and irrespective of class will give a reflection of equality and fairness for all before the law. Falana said under Section 17 of the 1999 Constitution, there shall be equality and equal rights for citizens. It what seemed like a satire at that book presentation. Now, when we look at these former governors, I'm not a legal luminary anyway, but then I have one in the studio with me this morning who will be shedding more light on that presidential pardon and also the extent of how and when the president should give presidential pardons. Now, before I even go into the program proper, we find out that the reports as reported by Premium Times, a report from some of the officials of the anti-graft agencies who declined to speak but accepted later to speak under anonymity have also faulted the present administration for thwarting sabotaging and sabotaging the fight against corruption. Now, a report by the Premium Times on April 18 said here that officials of the Nigeria's anti-graft agencies, EFCC and ICPC, who spoke under conditions of anonymity, say their morale and commitments to work have been affected by the controversial presidential pardon of Johnny Nyame, former governor of Taraba State, and Joshua Dariye, former governor of Plateau State. Now, both men were convicted and jailed for stealing state funds. Now, officials of the two institutions, in separate interviews, under condition of anonymity, lamented the pardon and accused President Muhammadu Buhari of sabotaging the anti-corruption fight, asking not to be named for fear of victimization. That's a report coming from Premium Times. Now, I have in the studio with me this morning a legal practitioner, notary public, and head of Department of Business and Industrial Law Department at the Ekiti State University, Dr. Michael Afolayan. Thank you so much for joining me on today's edition of the program, sir.
Thank you very much, Mr. Bamidele. Good morning, and good morning to our listeners.
And when you heard the news of that presidential pardon, Dr. Afolayan, how did you feel? What did it sound like? For a president that says stopping our corruption seems to be the basic mantra of his campaign and all that. So, what does that sound? How does that sound?
Well, first and foremost, when I heard the news, it wasn't really, something strange, because it wouldn't be the first time, that a president or a governor will grant pardon. But you see, along the line, news began to surface as to who and who were on the list. As a lawyer, I know that by law or by the Constitution, a president or a governor is empowered by the Constitution to grant a state pardon to someone who has been convicted of a crime, who has been found to be guilty of a crime and sentenced accordingly. So, looking at the list, the two names of the ex-governors who were hitherto convicted of offences bordering on embezzlement of funds and sundry matters, and were jailed accordingly years back, stood out. And then it called immediately, because a lot of persons started giving their reactions, and then it called for looking at the matter, both legally and then morally, even though we know that in Nigeria we operate on the rule of law. So as long as we have complied with the law, well, the question of morality will now be a question of debate as to the integrity of the person who has taken the step. So it's of a mixed feeling up to now, and we have had a lot of arguments both in the legal arena and even in the moral court. We've had so many persons giving it different interpretation, especially looking at the political implication. In Nigeria, there is hardly anything that is done that you won't find a political undertone, lying under it. So, unfortunately, this matter is also having a political undertone to it, and we can hardly, look away from it, looking at the implication on the two persons who are granted state pardon. I mean, the ex-governors.
But then, Dr. Farah, let's look at what the law says about state pardon. I think it's imperative that we look at what the law, and to what extent can the president issue state pardons to any convicted person?
Well, thank you. You see, crime, which is also called offense, has to do with when someone has done something that is prohibited by a written law in Nigeria. Specifically, Section 36 of Section 12 of the Constitution, states that nobody shall be convicted of any crime in Nigeria unless that offense has clearly been written in the law, not just in moral now. Morality has to do with standard of, rule of standard that is set by the society. It may not be written. Anyway, for example, you wake up, you prostrate to greet your father in Yoruba land is a moral. It's not contained in any law. So we have a lot of rules of morals like that. But when it comes to crime, it has to be a transgression that is specifically prohibited in a written law. And not only that the law has now stated what is the punishment for that transgression, for that offense. And so, where somebody has maybe acted or omitted to act in contravention of a written law, which has also stated a sanction or punishment for such an act or omission, then we say such a person has committed a crime. And when a person has committed a crime, then is probably arrested and then taken to court, where he is tried in accordance with the provisions of the law. And if such a person is found guilty by a court of competent jurisdiction, then he is punished accordingly. Now, this punishment, according to law, is what we call conviction. When a person is convicted, he remains a convicted person. Even after serving his punishment, he still remains a convicted person. And that has implications under the law. For example, if you want to contest for election in this country today, one of the things that can stop you under the law from contesting for an elective post in Nigeria is being convicted of a crime, especially crimes that have to do with financial impropriety, dishonesty, fraud, and so on and so forth along that line. So it has an implication. So if you say, well, yes, truly, I committed an offense, but I have served my punishment. What else do you want from me? Like in Yorubas, they will say, but under the law, there is still more he has to do. Because that toga, that shame of being an ex-convict hangs on his neck. Now, what does the law has to do to remedy some of these situations? Now, let me say something before I move into that. There are some crimes or offenses that when somebody commits them, it may not actually be due to that person's indiscretion. There are some offenses you commit blatantly, and you are not even remorseful for it. You don't even feel remorseful for it. There are some offenses that are committed due to mistake. There are some offenses that are committed by necessity. Let me give you an instance. There is this case of 1884 in England, Aaron Dudley and Stephen. Some people traveled to the sea. They were on an expedition on the sea, and then storm came, and then they were lost in the storm, and for many weeks they were for days they were on the sea, on the high sea. Lost at sea. The water around them was salt water. They couldn't drink it. The food that they had with them was finished. by the time they got to the 9th day, they were dying of hunger. There were 3 of them on the boat. One of them 14 years old, the other 2 adults. At a point in time, they had to take a decision that if we want to survive, although they still had the hope that they would be rescued, but that if they had to survive, then they had to eat one of them. And so they casted a ballot, and then it fell on that 14-year-old boy, and they killed him, and they ate him to survive. Now, eventually, they were rescued, I think after the 14th day on this. I'm talking about life, something that happened. This is not a Yoruba movie. Now, eventually, they were rescued, and then they were taken to court. They were arraigned for murder, and they were convicted of murder. And then eventually, they were sentenced accordingly. Now, when you now look at it, at this particular kind of crime, will you say that these people were absolutely wrong? It was something they had to do to survive. So there are some offenses like that may happen. For example, political, they may rope somebody politically because they want him to go, and then, okay, let's look at the case of former President Obasanjo. He was convicted of treason, felony, trying to take over the government and all that, and he was sentenced. It was believed that he was going to die in the prison, but eventually God rescued him, and he later came back and was granted the same state pardon, and so he later became the president and all that. So, in order to give room for this kind of a thing, Constitution now allows for the president and the governor to grant what is called prerogative of mercy. Prerogative of mercy in the sense that when you say something is prerogative, it means it is discretionary, in your discretion. So, as a state, the state also has the discretion, but the power to grant this pardon is now granted to the president in Section 175 of the Constitution, and then the same power is granted to the state governor in Section 212 of the Constitution. Now, for the president, Section 175 of the Constitution says that the president may grant any person concerned with or convicted of any offense created by an act of the National Assembly a pardon, either free or subject to lawful conditions. So the president, by that section, has discretionary power to grant pardon to somebody who has been convicted of an offense that is written. You know, I've said that for a crime, it has to be written. But it has to be in an act of the National Assembly, a law that is made by the National Assembly. So if somebody is arraigned for a crime or an offense contrary to an act of the National Assembly and is convicted accordingly, then such a person can be granted a pardon by the president. Now, it also states that he may also grant such pardon to, or respite to a person, or a respite either for an indefinite or for a specified period. It may be indefinitely, or for a specified period of the execution of any punishment imposed on that person for such an offense. So it means if such a person has been given punishment but is yet to serve that punishment, the president may grant him respite, either for a short while or for a very long time. We have seen examples of that in foreign countries where somebody will be sentenced, but they will say he will not go to prison until the next 2 years, probably to allow him to do some things, and then yes, of course. So he may grant him a respite or indefinitely. Then he may also substitute a less severe form of punishment for such an offense. He may substitute a less, punishment. Then he may also remit the whole or any part of any punishment imposed on that person for such an offense, of any penalty or forfeiture otherwise due to the state on account of such an offense. So this power is granted to the president. Section 212 also grants similar power to the governors. But the power granted to the governor is with respect to offenses committed under a law made by the House of Assembly of a state. Yes. So that is the difference between the power of the president and the power of the governor to grant a pardon.
What that of the president
is for the act of National Assembly. For the governor, it's for the laws of the, made by the House of Assembly of the state.
Doctor, let's look at it. Are there limits to the powers that a president can authorize in granting state pardons? Yes.
When you look at this constitution, of course, anything that is not contained in the constitution, it means that the president is not restricted by it. From what we have in Section 175 of the Constitution, the provision does not limit the kind of offense or the type of person or the magnitude of the offense that the president has the power to grant pardon on. No. That means the president has absolute discretion to grant pardon to anyone. Either he has committed a murder offense, he has committed a political offense, he has any offense, as long as that offense is an offense, because that offense was not qualified in the Constitution. It could be any offense. So the president has the power to grant that pardon, but it is a discretionary power. Now, when we say a power is a discretionary power, in several decisions of the court, the decision of the Supreme Court of Nigeria, which is the highest court anyway, it has been stated, because when you say discretion, there could be a challenge as to what is the particular offense that a person has committed. Now, in order to reduce, to not to allow somebody to now in his own private will begin to do something that is not permitted under the law, such discretion is to be exercised based on what we call judiciously used power. It must be in accordance with what is fair, what is right. It must be judicially and judiciously exercised. And the Supreme Court has also established that in different cases. Now, the power of the president to exercise this discretion is now made subject to advice of the Council of States. There is a body called the Council of State established by Constitution in section 153 when it was establishing some bodies. Now, it now provides that such power, before the president exercise such power, he must seek the advice of the Council of States. Now, advice, when you say advice, it is not saying approval. Approval is different from advice. Advice is, I want to do so thing. No. Well, they may advise that, but Mr., don't you think we should exercise patience on this or discretion? If he accepts the advice, he may step down. If he does not accept the advice, and that's why some people will say advice is a useless exercise, because it depends on the person who you are advising, if he's going to take it or if he will not take it. Now, the power that is granted the president in that section, he said, in relation to person concerned with offenses, it may also be with respect to person who has committed offenses in the army, in the navy, in any of the military and the paramilitary. So legally speaking, the president and the governors have the powers, to exercise those discretion. Yes.
Now let's look at the morality argument, because I know that someone of legal luminary stature or would not have been speaking, doing double speak if there was no issues involved in all of this.
Yes.
Now, when we look at the personalities that were involved, we're looking at the morality angle of it now. Let's leave the legal law courts and the benches, and let's go to the court of the people, which is that of morality.
Yes.
We ask ourselves the big question: for a government that says it's very committed to fighting corruption, and we look at how much over the years the EFCC and the ICPC, two main organs of corruption in the country, have been empowered across time to fight corruption. We see the personality of the chairman of the FCT, Bauer, who also says he wants to fight corruption at all. Now, we look at this also, the fact that these two governors were only just recently convicted in 2018 and 2018 for this jail term, just 3 years into their jail term. They've not, for I think it was 14 years, they were supposed to spend were jailed for 14 years, but they've not even spent up to 3 years of their jail term. Now, that's one angle on the other side. Now, there are also people that are arguing that it's basically geared towards the 2023 elections, and that these two persons that were convicted were very strong members of the All Progressives Congress, and the president needs them for the APC or the 2023 elections. But then let's look at the issue of morality now. These are people that have been convicted for stealing state funds to the tune of 1.6 and 1.62 billion naira. Were there other things that the president could have done rather than release these persons indefinitely?
Yes, I think that brings us to the issue of morality. You see,
is it permissible in court, morality also?
Yes, you see, unfortunately, law is law, moral is moral. Or there are some offenses that would be violation of both legal rules and moral rules. And there are some offenses that will only violate legal rules. I mean, they may not offend moral rules. For example, if you wake in the morning, you don't greet your parents. It is not written in any law that you should be punished for that. So they can only decide, well, morally we will also punish you, we will not give you food in my house, and you know all that. Now, but this kind of offense, which has to do with embezzlement of funds, dishonesty, fraud, and all that, they violate both the moral and the legal rules. Now, the president has taken the step to pardon them, grant them pardon in accordance with the legal rules. But what about the moral aspect of it? You see, when the Constitution gave this power, it was with the mind that at any point in time, whoever is the president or the governor will be persons that, if you look at the oath of office of the president and of the governor, you will see that their oath of office has clearly established that the persons that will be in such an office will be persons that will not allow his personal interest. Because part of the portion of the president's oath of office is that I will not allow my personal interest to influence my official conduct or my official decisions, that I will, to the best of my best ability, preserve, protect, and defend, and blah, blah, blah. Now, it means that whoever is to occupy those offices is expected to be a person of high moral standing. And so, the Constitution does not have issue with that. But unfortunately, in Nigeria today, there is hardly any step that is taken that will not have some political connotations to it. So, there is definitely no how you can rule out political influence on this pardon, especially to, Dariye and the other man. Now, in most cases, the court always try to balance between morality and law, but unfortunately, in most of the cases, the hands of the courts are also tied with the legal rules because they have to go by legal. It is not the moral. It is only where you have the law backing up a moral rule on an issue that the court may be able to pronounce on it. But in this instance now, the pardon that is granted to the two governors, let us look at it from the angle of corruption. When you look at the Corruption Perception Index of the Transparency International, you will see that Nigeria is on number 149 out of 180 countries.
TI index.
Yes, TI index, the current one. That means Nigeria we are below. In terms of corruption, we are almost finished. But unfortunately, when you grant pardon to persons of this character, it kind of communicates that the state is giving a tacit support, especially when you look at the enormity of the resources that have gone into, for example, arraigning this person, trying them. Do you know that even the law enforcement agencies, when they go after these people and when they take them to court and they do all this, do you know that they get threats to their persons? Most of them do these things. Of course, they do it at the risk to their lives and their family. And then unfortunately, when you have gone through all this and then you have a pardon coming in to just water down everything you have done. So when next you want to take a step, such persons may be wary in their mind and then look at it that even if we get this person now and eventually they will still grant this person pardon. So it kind of reduce or take away the passion of those who go after these people. And so it is not, morally speaking, it is not a very good decision at this time. And that is exactly what we've heard from so many persons who have also criticized these decisions. And that is why Femi Falana, the Lanesik Femi Falana, is also saying that if you are going to grant this kind of thieves pardon, why not grant all the thieves in the court pardon? And all that. So I am also of the opinion that at this time it was not too well, even though it could be politically right for them, but morally speaking, and in the interest of the state, it is not too not too good.
Okay, we'll take a quick commercial break. There's still Viewpoint on Fresh 106.9 FM. We'll be right back after this time out. Do stay tuned.